Yes, I am.
Excellent. All righty, let's rock and roll. Welcome back, folks, to another Rev Real Estate Live. Really excited about today's webinar. I feel like every week I say this is probably one of the most important aspects of multifamily investing, but it is. A lot of the things that we share on these calls are some of the most essential and basic things as you get started investing in this real estate space. My name is Dallin Schultz. I'm the host of this Rev Real Estate Live webinar and president of Rev Equity Group. So I got two partners with me. We got Hillary and Paul that are going to help guide us throughout the call. And we are going live on multiple platforms. So this call is being recorded, and we send out these recordings every Tuesday morning. They are all uploaded to our YouTube channel. So if you want to go in and review a previous recording, you'll have access to that. So typically the way our flow goes is we go through the presentation and then we open up for Q&A towards the end. However, on this week's webinar, we're going to be talking about asset protection, how to set up, how to structure yourself to limit exposure to various assets that you might own or manage when investing in multifamily real estate. So super excited for our webinar this morning. We have Bo, who's joining us from Arkansas. Is that correct, Bo?
That's right. That's right.
Excellent. So what we'll do is we'll go ahead and turn the time over to Bo. And Bo, why don't you start off by giving us a little introduction about yourself, what you do, and then we can dive right into it.
Yeah, excellent. I've got some slides here. Let me see. Am I able to share my screen?
You are. I just enabled you to.
Okay, let's try it again. Okay, here we go. All right, excellent. Okay, yes. So my name is Bo Fugit. I am a attorney licensed here in Arkansas.
Hey, Bo, just so you have a heads up, we are seeing your note slide.
Excellent. Let's try that again. Let's see here. There we go. How about that?
Yep, we got the presentation there.
Okay, great. Sorry about that. Okay, yes. So my name is Bo Fugit. I am an attorney licensed in Arkansas. Before I started my current law firm, which is Fugit Law PLC, I worked at a number of firms where I did commercial litigation, some commercial transactions, a lot of commercial transactions, mergers and acquisitions, corporate compliance, and governance, and that type of thing. I did a lot of real estate transactions, and I would say for the past about year or so, my practice has been almost exclusively in real estate securities. So what I mean by that is real estate funds, real estate syndications, that type of thing. I have done some crypto deals and some oil deals as well in the securities world. So that's been a lot of fun. But yeah, that's kind of my legal background. I was in the military as a JAG for a while as well. So I do have experience doing that type of stuff. But first and foremost, I am a real estate investor. Real estate has been my passion for a long time. And I tell people that I am a real estate investor that happens to be a lawyer, not a lawyer that happens to invest in real estate. So this really is my passion, and I'm really excited to be here. I bought my first multifamily property back in 2009, right when I got out of the Marines, and I've just been investing since then. I do manage a smaller real estate fund, but most of my holdings are not with other partners, just holding myself. But I do actively syndicate deals from time to time when the deal calls for it. Yeah, like I said, real estate has always been my passion. It's what I wanted to do for a long time. And eventually it got to the point where I've been doing real estate long enough that I didn't really have to practice law anymore. And that is when I started Fugit Law. I went out and became a solo practitioner. And at Fugit Law, my goal, kind of the vision of Fugit Law PLC, is to give legal services to real estate investors. That's where I try to limit my clientele to. I don't do any type of advertising or anything like that. So far, all of my referrals have been via word of mouth, which has been totally adequate for me, keeps me busy enough. And yeah, it allows me to kind of gives me the freedom to focus on just the things that I want to focus on, i.e. real estate and legal issues involved with real estate. And it's also allowed me to pursue my own real estate ventures. So a little bit about me, but yeah, we'll move on from there. I want to say thanks again, Don, for having me, and we'll get into it. So here's my disclaimer, right? No legal advice is going to be given today. This presentation is strictly for educational purposes only. Everyone's circumstances are unique, and anything that we talk about, these are just going to be broad topics, broad considerations that you should have in mind when putting together your asset protection plan, specifically as it applies to real estate. So I would encourage all of you, before you invest, or if you've invested already, I would seek out qualified legal counsel, someone that understands real estate investments, understands real estate securities, right? If you're investing in a fund or a syndication, that type of thing. But have someone review your structure, look at your plan, and tweak it based on your unique circumstances, right? Everyone has different goals and circumstances. So it really needs to be tailored to you specifically. Okay, so this is an overview of what we'll talk about today. Just some basic things to consider. Talk about a couple different models that you can use kind of for your asset protection plans. But yeah, moving on. Okay, asset protection for real estate investors. So this is not a one-size-fits-all approach. Like I said before, everyone has their own unique set of circumstances. Everyone has their own unique goals. Everyone has their own unique considerations that they need to take in mind when setting up their asset protection plan. No asset protection plan is impenetrable, meaning that there's always the possibility, no matter how many entities you set up or what you put in place, that you can be sued and lose your assets. Like I mentioned before, I was in the Marines before I started practicing law, and there's this term in the Marines whenever you're putting up a defense, or really it's anywhere in the military, but we call it defense in depth. And that's really what a good asset protection plan is, right? There's going to be layers to your asset protection plan. Point being, if they get past your first line of defense, there's a second line of defense protecting your personal assets from the creditor, whoever's coming after you. And I've got some slides here in a little bit that kind of go through like organizational structures, and you can see what I mean a little bit better in those. But today we're just going to talk about some good strategies to consider and discuss with your advisor when putting together your plan. A good asset protection plan should do really two things. Number one, it should protect you from your assets, and it should also protect your assets from you. So there should be what I refer to as a top-down, bottom-up approach, right? We've most probably all heard of limited liability companies, right, or limited liability partnerships that limit the individual owner's liability in the event something happens. So take, for example, you own a piece of real estate, you have it in a limited liability company, someone slips and falls. In theory, they should be limited to suing the limited liability company, not you personally, or nothing's going to stop them from suing you personally, but in theory, they should get a judgment against the limited liability company, not you, if in fact, the limited liability company was at fault, if it was, so there was some defense. And at the very least, it should keep that creditor from getting your personal assets. The other approach, right, the top down or the bottom up, is to protect your assets from you. So in the other scenario, you own real estate, maybe you've even got it in an LLC, and on your way to work, you get in a car wreck, you're at fault, it's determined that you're at fault. And so now they come after you, they're already coming after you personally because you were the one in the car, right? So how do we keep them from getting your real estate at that point? How do we protect your assets from that direction? So when putting together these asset protection plans, those are the two things you want to keep in mind. It's, you want to protect it from both directions. Okay, so some of the common goals of an asset protection plan would be limited liability. think that's fairly obvious, but anonymity is another one, right? So think about public figures, for example. Someone were a public figure, they probably wouldn't want the general public to know that they owned a piece of property. I've actually been amazed. I've gone out and searched TV personalities and have found their personal residence just through property records. For whatever reason, they don't have that great of an asset protection plan. I'm able to gather information on them and know exactly what assets they're holding. They may have other assets that they have protected better, but that's another goal of a good asset protection plan is anonymity. And then the other thing would be generational wealth, right? If you have children or heirs, understanding how you can structure your assets and how you can hold them to do things like avoid probate, avoid estate tax, that type of thing, right? So those would be the common goals. Common creditors, this would be judgment creditors, bankruptcy, divorce, casualty, disaster, right? The actual physical asset itself being lost, and then taxes too. How do we do this all and pay the least amount of taxes? Going back to the comment that I made that a good asset protection plan is kind of a layered defense, you can get very complex with these, and you can have this entity that owns this entity, that owns this entity, that owns this entity, and really spread it out, separating you from the asset, keeping, ideally keeping those layers in place so that either you can't be reached or that the asset can't be reached, depending on what way the attack is coming from. But there's also costs and taxes to consider with that, right? So finding that balance in your plan to where it's not overburdensome, and it also keeps you protected to the extent that you need. Another comment on anonymity, right? Like I mentioned before, I used to litigate, and it is not uncommon for plaintiffs' attorneys before they bring a suit at all to do what I was talking about, to do some research on the possible defendant, to find out, right, is there any blood in this turnip? Does this person have any assets that I can go after? And if you can't find any assets, or if there's no reason to think that this person is a wealthy individual, then maybe I'm going to forgo bringing the suit in the first place because I don't think it's worth my time. Or as a lawyer, I'm going to turn down the case. This person that's come to me with a possible claim, I look at it, I say, look, I just don't think it's worth it. I don't think we're going to be able to get any money from this person, so I'm going to forego this. So that's the other thing about anonymity and a good asset protection plan is it can actually stop litigation before it ever starts, not just protect you after a judgment.
So just to reiterate that, Bo, and I've heard this before, because initially when I got started in business, you hear about the asset protection, the LLCs, and I was under the impression it prevented me from being able to get sued at all. And that's not the case. You could still get sued. And what was explained better to me and what you just brought up again is it worth the attorney's time? Because most attorneys don't want to work for free. That's why they became attorneys in the first place, because it could be a very well-paying job, and they can help make an impact and a difference. So it's not that you can't get sued even if you have these layers in place. It's just, is it worth everybody's time? Everybody has a value of their time. Everybody has, like, how much is it worth an hour to be doing this task? So that's the benefit of having these layers, and the anonymity is to limit the desire of any attorney wanting to try to come after you, because nobody wants to work for free at the end of the day.
That's right. Litigation is complex, it's time consuming, it's expensive. It takes a lot of time. And I can't tell you how many times I have talked to people, and maybe they even have a legitimate case, but at the end of the day, the person that they're going after doesn't have anything to show for it. So it's just, the juice is not worth the squeeze. So maybe you do have assets, right? But if you can structure this in the right way, so it looks like you don't have any assets, then you'll be much better off. So, okay, we'll go on to the next slide here. All right, so today I'm going to talk a lot about corporations and LLCs and limited partnerships and trusts and all that sort of thing. But the first layer of defense in any good asset protection plan is insurance, right? This is common to all asset protection strategies, especially with real estate, is having good insurance and understanding what your insurance policy actually covers. Like I said, no plan is impenetrable. And I would say having proper insurance is probably the most important thing. We'll get into it later, but a judge can always what we call pierce the veil, right? Even if you have the right entities put in place, a judge could say for whatever reason that they're going to hold you personally liable. And in theory, even if you were held personally liable, if you have adequate insurance, you don't have to worry about it because your insurance is going to handle that. So poor structures, poor asset protection plans and structures can be mitigated with good insurance. So just remember that from the outset. Some of the stuff, it can have a tendency to get confusing. You may have to read about it and learn it a few times, but insurance should really be your first line of defense. Whenever I consult with real estate investors in particular, I'm putting together asset protection plans. I always start by reviewing their current insurance policies, right? Or at least asking them if they don't have them in place, talking with them about what type of insurance policy that they might want to get and what questions that they should be asking their insurance agent.
Bo, quick question for you. And we actually have another attorney on the line as well, so I might pose this to Eric as well if he's available. What's the root of all litigation? Why is it that people litigate in the first place?
Well, so essentially, when you litigate, you're looking for two things, right? You're either looking for an injunction. You're either wanting the court to make someone stop doing something, right? So, for example, you own a piece of property and your neighbor starts building a house on it, right? You might sue them to have the judge say, hey, quit building that house there. You don't own the property. That would be an injunction. The other thing would be damages, right? If they feel that they've suffered some sort of loss, right, then we're going to put that into a dollar amount. Sometimes it's easily put into a dollar amount. Sometimes it's hard, right? If we're talking about the loss of a loved one, but we're going to put a dollar amount on it and we're going to get damages. So ultimately, that's what you're looking for in litigation. And I don't know if someone else wants to jump in, but
Eric, if you're available, how would you answer that question?
No, that's the right answer. I mean, most of the time it's money driven. At least that's what it should be. Although litigation can be very emotional, which is what oftentimes will run up the cost and the length of the litigation that was referred to. But when we're dealing with businesses, typically who I'm representing, they view it as a cost benefit analysis. But that's not always the case.
So both of you touched on it, and I'm glad I posed that question and you provided the answer I was fishing for. But from my understanding, a lot of it comes down to the potential financial damages or gain that could happen. And so to Bo's point, having that property insurance in place, the real property and personal, if that can satisfy the demands or the needs of that individual making a suit, then that is a very effective way to get through it, to get through the process.
Yeah, absolutely. It comes down to money. I mean, it really does. I mean, even an injunction, right? You're trying to stop someone from doing something so that you don't have to spend a bunch of money to fix it, or so that they don't cause harm to something that you've already spent a lot of money on. I mean, yes, it's almost always a money thing. And the cost benefit analysis, it's like any business decision. People are going to do a cost benefit analysis. There is a lot of emotion. We get into things like family law and stuff like that. There's a lot more emotion involved. But for what we're talking about with real estate, it really does, for the most part, come down to money. I have represented, families in the past, right? Where one member wants to sell the family farm, the other one doesn't. And that's more, emotional driven. But for the most part, it is going to come down to money. So, okay, now I'll talk about some different types of insurance that you should consider specifically whenever you are looking at real estate syndications and real estate funds, that type of thing. So you got real or personal property, right? What are you going to insure? Anyone that's been involved in real estate syndications for a while understands that it's more than just having a piece of property, right? A real estate syndication or real estate fund is a full-fledged business, and there's going to be personal property associated with that business as well. So trying to understand, what are our assets here besides just the property, and are we adequately covered with insurance? Real estate generally increases in time, whereas personal property typically decreases. So work with your agent to make sure that you understand how the insurance policy of the insurance company determines or the increase or decrease in the value, and what does that mean for your coverage and your premiums, right? Is your premium going to go up over time? Is it going to go down over time? Are they going to value something different? And whenever it's time for you to actually collect insurance, they're going to give you less than what you thought you were entitled to. So understanding that, that kind of hits on replacement costs versus current value. This may seem like it would be the same thing, but it's not. Replacement cost is what it sounds like. How much would it cost to replace the property? How much would it cost to rebuild this apartment complex if it burned down? I represented a client one time, called me in the middle of the night. His apartment complex was on fire, right? Thank goodness nothing happened to anyone, but he had adequate insurance in place, and it ended up financially being a great thing for him because he was insured. The property was old as it was, and he got to build a brand new apartment complex and came out on top. We didn't have to worry about any of his, entity structures or anything like that. He had the right insurance in place, and it worked out to his benefit. Now, I'm not telling you to go burn down any apartment complexes so you can collect insurance money. That is fraud, and you don't want to do that. That's a crime. But
that's a whole nother level of litigation that we're not going to get into on this call, right?
Right. That's right. Whereas, so that's replacement cost. The current value, on the other hand, the insurance company can actually reduce the cost, right? Because they could say, based on the property's age or perceived value or depreciation, whatever, they could say that the property is actually worth less than it would cost you to replace it. So for most real estate deals, I would say that, the replacement cost is the way to go. Understanding that this presentation is really geared for passive investors. Maybe you're not the one actually out there making the decisions about what type of insurance is put in place, but I would at least pose these questions to your sponsor, right? Ask them what type of insurance they have. Make sure that they understand what the policy actually covers, right? No one likes reading insurance policies, but somebody's got to do it. Somebody's got to have a good understanding of what is actually covered by the policy. And if you're working with a sponsor that doesn't understand that or can't answer your questions about the insurance policy, that might be a red flag, or it might at least key them on something that they need to look more into. Next is liability insurance. We kind of hit on this before, but real estate funds, real estate syndications are a business, and it's more than just buildings and lands. Slip and falls, right? You're dealing with tenants. Slip and falls, you could have discrimination claims, right? The Fair Housing Act. You could have a tenant say that you violated something like that, and maybe you get a judgment and they said you did. So liability insurance is something to consider. Cyber liability insurance, at first glance, you may think that this would not be needed for any type of real estate investments, and maybe it wouldn't. And I would agree with you that most real estate investments probably don't need cyber liability insurance. But, I have worked with syndicators in the past, people putting together funds in the past where there was an element of the deal that was crypto tokenization was a part of it. So for example, there you buy real estate, and with your subscription agreement into the syndication LLC, you receive some type of crypto tokenization, right? That you can then fractionalize and sell off and this and that. Those types of deals, okay, now cyber liability insurance might be something that you want to think about more. Also, it could be as simple as, will the syndication be taking credit card payments from somebody? I don't know if you're probably going to have a property manager that's going to handle all of your tenant relations, but are you going to be accepting credit card payments, right? So cyber liability insurance is going to cover things like loss of data, website liability, identity theft, business interruption, credit monitoring expenses, cyber extortion, ransomware. So is it needed for every real estate syndication? Probably not, but it's something to consider. Okay, so next, director and officer coverage, so also known as D&O coverage. This is insurance against the actions or the inactions of the corporate directors and officers. Right. So there's generally three types. There is what we refer to as A-side coverage. And A-side coverage, this covers the directors and officers from the wrongful acts that they committed in their capacity as officers and directors that the company doesn't indemnify them against, right? B-side coverage covers the corporation, right? So A-side covered the directors and officers. B-side actually covers the legal entity itself from the wrongful acts committed by the directors and officers for which the company has indemnified them. And then you've got C-side, and that covers the losses suffered by the corporation for the wrongful acts, regardless of whether there's any type of indemnification. So most real estate syndications are put together with some type of corporate entity. You typically have a sponsor that is managing the asset in some way or the other. This can be a very litigious area, especially when it comes to real estate investing. So, it's something that you should at least consider whenever putting it together. And it's a question that you should ask your sponsors if they've considered it and why they haven't decided to get a D&O policy. Next is umbrella insurance, right? Or umbrella policies. And these are really, you can think of these, if insurance is your first line of defense, an umbrella policy would be the second line of defense. And what the umbrella policy is, it's going to fill all the gaps. It's going to say, hey, I think, we're covered, but we want to buy just this extra layer of insurance to protect us in the event that we misunderstood some of our policies or something slips through the cracks, right? It's that second layer of insurance defense that you can put in place. And it's definitely worth something to consider. Again, this is all a cost benefit analysis, risk reward, right? You have to determine, is the cost of this insurance, does it make sense, right? Or are you willing as an investor to accept this risk? In business, risk is inherent to everything we do. And if you get so much insurance that you totally alleviate your risk, your insurance bill maybe, it may just not work. The numbers might not work, right? So you always have to look at that and determine what your risk tolerance is, what your risk exposure is. And that's something that an attorney should, and an insurance agent should help you identify. And then finally is read the fine print. I touched on this before. No one likes reading insurance policies. I know I don't, but it's important. Somebody needs to do it. As an investor, if you want to take the time to read your insurance policies, I would ask your sponsor for them. I think that's great. At the very least, the sponsor needs to be looking at these, talking with the agent about the parts that they don't understand, and making sure that they feel like all the necessary risks have been considered and you have the proper insurance put in place for that. So anyways, I know I just talked a lot about insurance. Before we move on, are there any questions about insurance? All right, well, I'll move on. I got one more slide on insurance. These are some questions that I would ask an insurance agent, right? First off, you want to work with an agent that has experience. As in all things, there are people that are new, there are people that are good, there are people that are bad. In dealing with something like this, right? An expensive asset like multifamily properties, work with an experienced real estate agent would be my advice, right? Understand what your premiums and deductibles are. Talk to your agent about their relationship with one another, and can we lower the deductible, right? And how does that affect our premium? Vice versa. Same thing with co-payments. Make sure you understand those, and you can play around with those most of the time to find that sweet spot. We talked about it before, but replacement costs or current value for most real estate deals, I would probably recommend you get replacement costs. Real estate coverage, personal property coverage, renter's insurance, right? Is the syndicate, if you're doing multifamily or really any type of real estate, are you going to require your renters to have insurance? And if so, what are the terms of those policies? What are you going to require there? You want to ask, what happens if we do go to litigation, right? What is the insurance going to cover if we do find ourselves in litigation? Are they going to pay for that, or do you have to pay for that? We mentioned it before, but litigation is not cheap. So who's going to be paying for that? And then finally, director and officer liability, understanding if there's anything that is protecting the company and protecting the directors and officers, from their actions of each other. All right. Okay, next we're going to talk about some different limited liability entities that are commonly used in real estate syndications. So we got corporations, limited liability partnerships, limited liability companies, and trusts.
And Bo, I'll ask that we just for the sake of time, maybe very briefly touch on the others, but a lot of the entities in the situation we're in are LLCs. So I'd like to dive in and emphasize that a little bit.
For sure. And I will go through this. And I think you'll like my slide on LLCs because that is really the ideal entity to use in most circumstances for real estate syndication. So quickly, we'll go through corporations, right? Bottom line, corporations are great. They have their purpose. They're generally not the right tool for real estate syndications. They're generally not the right tool for investors to use for their personal holding company. And we'll kind of get into that a little bit more too. But corporations, they've got their place. Typically, it's not the best for real estate syndications. We'll move on to limited liability partnerships. Limited liability partnerships, on the other hand, sometimes can be the right tool for real estate syndications. Used to be this was the only option. LLCs were only created in the late 1970s. The Wyoming was the first state, and then I think it was the late 80s before the IRS even acknowledged really LLCs. So LLCs are fairly new when it comes to legal entities. Before LLCs, limited liability partnerships were really the tool that syndicators had to use. They're still used sometimes. So if you see down there at the bottom, I have a slide on a little bullet point on Canadian investor considerations, right? I've done a number of funds where a significant portion of the capital that was being raised was coming from Canadian investors. If you are going to be working a lot with Canadian investors, then you're probably going to want to do an LLP because Canada's tax laws are different than ours. And if Canadians are investing into an LLC, then they'll actually end up being double taxed. Is my understanding. Again, I'm not licensed in Canada. I'm certainly not a Canadian tax professional, but it's something I've just learned that through my experience. These are used from time to time. The reason that they're not really preferred now, for a limited liability partnership, you have to have at least two parties. You have to have a general partner and a limited partner. The general partner takes full personal liability. The limited partner has none. All right. So whereas when an LLC, everyone has that limited liability. There are ways to kind of alleviate that. You can have an LLC be the general partner, and that reduces risk. But with the advent of the LLCs, this is it's really what most syndications use. So here we go. LLCs, this is the most common use today. It's the newest entity type. Limited liability for all members, not just the limited partners. So the same fiduciary relationships for the sponsors. So we didn't touch on that in the limited partnership, but the sponsors in a limited liability company that is going to syndicate real estate, they have a fiduciary to all of the passive investors. That fiduciary they have the duty of care, the duty of loyalty, and most importantly, the duty of disclosure, right? So that means that they have to look out for their investors, even above their own self-interest. So that's the same fiduciary duties that a general partner would have in a traditional limited liability partnership. The same thing applies in real estate syndications. Corporate formalities are allowed. They're not necessarily allowed in limited partnerships, but they're allowed in LLCs. LLCs are extremely flexible and they offer the most protection, and that's why they're mostly used today. Series LLCs are something that are very new, and they're not my favorite. I would not advise any client to use a series LLC when investing in real estate. In theory, I think they're wonderful, but the reality is they're so new that the case law has not been developed on them. There's really, to my knowledge, there have been no court cases as of yet that have looked at how do you handle a series LLC when one of the entities is being sued and the other's not. I realize I kind of just went into that with explaining what a series LLC is. Essentially, a series LLC was created, I think, for probably real estate investors in mind, where you just create one LLC and then you can have all these series of the LLC. So you have, main LLC, and then you have sub LLC 1, sub LLC 2, sub LLC 3, and you don't actually have to pay franchise taxes on those subsidiary LLCs, but they're still supposed to be the same distinct legal entities. A lot of people have problems with this. Most of the other attorneys that I've talked to that work in this area of law advise against using them, because again, it's untested. And until there's actually case law that goes in and starts interpreting the statutes and looking at specific fact patterns, I think that the risk outweighs any perceived benefit. All right, moving on. Okay, piercing the corporate veil, right? So we've talked a lot about these different entities, and it's all great. You can set up all these entities that you want to separate you from your assets and to separate the liability from the assets and yourself, but none of that matters if the corporate veil is pierced. And what do I mean by piercing the corporate veil? So limited liability companies, limited liability entities, no matter what they are, they have a veil of limited liability, meaning that they shield the owners of the company from personal liability. When you pierce that corporate veil, all that goes away. So what are some of the reasons that a court would look at an entity and say, yeah, you have this LLC put in place, but we're going to disregard it. We're going to decide that this is really just, smoke and mirrors. This is not a separate person, and we're going to come after your personal assets. Fraud is the number one reason. Okay, so courts will often pierce corporate veil for fraud. Another reason would be not maintaining separate legal identity, right? So let's say you have LLC A that has equipment, I don't know, trucks or something, and you start using the equipment of LLC A to conduct the business of LLC B. And there's nothing put in place like a lease of that equipment or something like that, right? You just start mixing everything all up. Okay, you've got I don't know, this property over here and this property over here, and you start taking the revenues from this property to directly pay for the expenses of this property that are held in separate LLCs. That would be another situation, right? Separating legal identities. That would be referred to as the commingling of funds. You see that fairly often, where people do not keep good books, they don't keep good records, and they start taking that rent revenue and using that to pay some other expense, whether it's a personal expense or an expense for another entity or whatever the case may be. So having good books is very important. The other reason that a court might pierce the corporate veil is having low capital reserves. If the court decided that the owner of that entity was intentionally underfunding the business to avoid paying creditors, then they might pierce the corporate veil for that. And then failure to follow entity formalities. So if your operating agreement says that you're going to have a meeting once a year, right, a member meeting once a year, and you don't have that for 10 years, and you haven't been following, common accounting principles, haven't been keeping good books, things like that, then a court might pierce the corporate veil. A lot of this will come down to state law, right? LLCs are a product of state law, and every state has different requirements and different rules put in place. Most of them are pretty similar, but states can vary. So that would be another way, right? If you weren't following those rules or those formalities, then a court might pierce the corporate veil. And then I hope you have good insurance at that point, because that would be just the same as if your name was personally on the deed, for example, if it was real estate. All right. Are we still got on time, Don?
Yeah. Let's go for about 10 more minutes or so, then we can open it up to some Q&A.
Okay, excellent. So this in front of you here, this is just a basic real estate syndication structure, right? Where we've got you'll see my arrow. We've got our real property here. We've got our syndication entity down here. We got our property manager over here, non-member manager, and then here's all our investors, or what we'll call our holding companies. So starting from the top down, we'll talk about all of this is put in place for asset protection. It looks overly complicated. At the end of the day, we're just people buying real estate, right? But so why do we have all these separate entities doing? Why does it look like this? It's all for asset protection at the end of the day. So take our real property, for example. The real property is owned directly by the syndication entity or by the fund, right? That's typically going to be an LLC, a non-member managed LLC. They own the property, but you have a non-member property management company that is actually running the management. They're the ones that are dealing with the tenants. Because if there is a claim for discrimination, let's say, we want them to have to sue the property management company, or we want the judge to say, yeah, the person who's at fault is this property management company, not the actual person that's on the title to the real property. I say person because an LLC, limited partnership, they are legal persons. So we want to, that's the first step, right? Property management company, hopefully they're going to be the ones, if there is a judgment, it's going to be on these folks, not down here. Coming down here though, we do have an LLC, right? So we're going to have a syndication LLC. This is going to limit the liability from the individual investors and from the individual sponsors. The same way that we have a non-member property management company actually managing the property, we're going to have a non-member management entity most of the time managing the syndication. And that's for the same reason. This is an entity, right? Oh, went too far. Let's go back. This entity, right, was typically an LLC, and the members of that are generally going to be your sponsors, right? The folks that are actually putting together the deal, raising the money, actually managing the asset, not necessarily property management, but actually managing the asset, making sure that everyone's getting their K1s at the end of the year, making sure that all the necessary disclosures are made to investors, answering investor questions. That is going to be a separate entity that makes all the decisions on behalf of this entity. Why do we do that? Again, it's going to lessen the liability of the actual entity that holds title to the property. If the person that's making decisions on behalf of the syndication entity does something that could violate some law or somehow receive some type of judgment, then there's a better chance that the judgment's not going to come here. It's going to go to this non-member management entity, and then boom, assets still safe, right? Last thing we'll touch on is the actual holding companies, right? These are the investors. So here we've got, I keep clicking. Here we've got passive investor holding in a trust. We've got passive investor holding in an LLC. And over here, we've got sponsors. Underneath, you'll see I have Class A's, Class B. Again, this is a basic real estate syndication deal where your Class A units or your Class A shares, right? Because that's what we're really holding here is stock in this company or membership units. You don't want to hold those in your personal name for the same reason that we don't want to put any of this stuff in our personal name. You want to hold that membership interest either in a trust or an LLC. I have my preferred method, which is an LLC. I like Wyoming LLCs for holding companies, and I'll talk about why. But that's the other layer too. Your sponsors, we call that a Class B because typically that Class B is received based on the efforts that the sponsor put into the deal, not necessarily money. A sponsor could also put in money and take a Class A share, for example. But anyways, that's the basic structure. Any questions on that before I move on?
Bo, speak to there's some companies out there that bring management in-house. So do they follow this similar asset plan here, asset protection plan?
So they wouldn't if the management is in-house, meaning you mean it's a member manager. Is that what you're getting at?
Yeah, they take on the property, the day-to-day property management.
Oh, sure. So it's how I would do that. I would set up a different entity. Again, it's one of those kind of cost benefit analysis, risk reward analysis that you just have to make and determine, okay, is it worth setting up another entity that's going to handle the property management as opposed to having the non-member manager actually manage the real property too. I've seen plenty of deals where this management entity they'll manage the syndication entity as well as manage the property. And that's fine. it's still the same theory that you're separated. Your limited liability is still in place. However, it's just one less layer of protection, if you will. But I wouldn't, if an investor came to me and I saw that the non-member manager of the syndication entity was also the property manager, I would not tell them that they, shouldn't invest or that they should be worried. I might point out there's another way that it could be done, but it wouldn't blow the deal. I'll put it like this way. If it were me, that would not, if it was a good deal otherwise, that detail would not stop me from investing.
Excellent. And as a passive investor, it's good to recognize and be aware of this structure. Even though you're not going to be the one putting it together, this is something the sponsorship team or the general partners, and that's another note too. You'll hear GPs, LPs kind of used incorrectly, just because that's kind of the jargon and the language. So even in this case, when you're using LLCs, you got the sponsors down here that are part of the members of the management entity. You might very likely hear them referred to as the GPs. And then over here, the Class A membership units, you might very likely hear that be referred to as LPs. So just be aware of that as you're vetting these deals and getting familiar with the jargon. But as a passive investor, Bo, what would be the best next step for a passive investor if they wanted to get involved in a syndication like this?
Great question. And that leads on. So there's two models that I would recommend. The first one is not my favorite, but would be the trust model, just setting up your standard trust, right? And then that trust can actually own membership units of the syndication LLC. You can, whenever you invest as a passive investor, if we're doing a traditional equity style deal, in syndication, what you're actually buying whenever you give the sponsor your money, you're not buying real property. You're buying personal property in the form of a membership interest in the syndication LLC. You can hold that interest in a trust or in your personal name or in a different legal entity like an LLC. So holding in a trust is certainly not a bad idea at all. This can protect you very much so if you were to personally do something, right? Especially if, let's say you were in a trust, you got a trustee and you've got the beneficiary. The trustee is the person that controls, right? That makes the decisions or really holds the property, whether it's real property or personal property, holds it in trust for the beneficiary. This goes back to like crusade times when people would go off to the crusades and they would say, hey, watch my fields for my kid, because obviously my kid can't go plow the fields and stuff. So I want you to operate the fields in trust for my child. That's where it comes from, but it just kind of helps you understand what a trust is. Most people probably knew that already, but the trustee is put in place to manage it, to manage the property for the beneficiary of someone else. Now, when you set this up, you can set this up a number of different ways. You can make someone else the beneficiary, or you yourself could be the beneficiary, right? You could be the beneficiary. You could have a different trustee, which is kind of why it's not my favorite for the direct line to hold real estate, just because I think LLCs are cleaner, and I think that all the benefits that you get from a trust, there are some LLCs that can give you pretty much the same benefits. But yeah, trust or state law specific. Power of direction, that's good to talk about. So a beneficiary in most states can have what's called a power of direction, meaning that they can tell the trustee what to do. Even though the trustee is the one that actually makes the decision, the trust documents will have the beneficiary gets to tell the trustee when to give distributions, for example. The good thing about a trust is, unlike LLCs that are registered with the Secretary of State in most states, or Department of Corporations, or states call it different things, but some government body, trust documents are not subject to public record. They can be subpoenaed. I mean, you could be deposed and have to talk about a trust, but generally a lawyer can't just go look up and see who the beneficiary of a trust is, right? What a lawyer can do, and what I've seen, and it puzzles me sometimes, is if you name the trust something, like if I had a trust and I named it Bo Fugit Trust, right? Well, then there's really probably not much question there as to who's involved with that trust. Now, maybe I'm the trustee. A lot of times if I hold actual title on something, let's say, both you get trustee for the XYZ trust. But as a litigator, I know that, hey, there's a decent chance that this person has some type of interest, equitable interest in this trust. And if I see, hey, if you get trust, both you get trust, owns all these different assets, has all these different assets, then I might come after that. So that's something to consider. I think I was all over the place a little bit with that, but
So in short, if you want to set up a trust, don't set it up as your personal name. Fine.
Yeah, it's good if it's going to hold, real property or something like that. Then yeah, I would pick a name that's a little bit different. Going back again to that anonymity. I do think that trusts are important for any type of estate planning and a full asset protection plan. But when we're talking about specifically real estate syndications, as far as that goes, they're not always needed. So this brings me into my favorite model, which is the Wyoming Holding Company model, and it's an LLC, right? The Wyoming LLC. Wyoming was the first state to enact LLCs, and they did it because they realized that investment is good. It's good for people to invest. It's good for people to take business risk, and it's good for those people not to be personally liable for those risks. So the LLC was created to give not only the general partner and the limited partner, not only the limited partners limited liability, but also this to give all the members that limited liability. So unlike a limited liability partnership, all the members in an LLC have that limited liability. Also, LLCs are generally very flexible. LLCs are a product of state law, so they're going to vary state by state, which is why I have picked Wyoming as my favorite. But they do vary by state, but generally they are more flexible than corporations. They're more flexible than limited liability partnerships as to how you set them up, how many classes of membership units you have, what type of duties that you impose on this officer or that officer. You can have an LLC with just one member. A member is the owner. That's just the term for an LLC. You can have an LLC with one member. You could have an LLC with many members. Right? They're very flexible. They're like I said, they're less complicated. Wyoming has low fees, so there's typically a fee, that you have to pay the Secretary of State to set it up. There's generally an annual franchise tax that you have to pay, but the fees are generally low. One of the other benefits of LLCs, you'll also get this with limited liability partnerships, but it's pass through taxation, right? So the LLC itself doesn't have to file a tax return necessarily. All income and loss is passed directly to the individual members, and so it's easier generally for tax season as well. So that's kind of LLCs as an overview, and now I'll get into Wyoming specifically. Why I like Wyoming. Wyoming does have low fees, but the great thing about Wyoming, and there are a number of states that do this, but Wyoming is the best, in my opinion. Wyoming, all the members are anonymous, right? So if I go to Arkansas and I file an LLC, on that public record, it states who the members are. I've got to list my name, or I've got to list who actually owns that. In Wyoming, they don't have that. And nowhere, if you were to go search for some Wyoming LLC, go to their Secretary of States and do an entity search, when you pull that up, you can't see who owns it. So unless I've done something silly, like I mentioned before, like name the LLC something like Bo Fugit LLC, then you're not going to know who owns it. You might see that, hey, 123 LLC owns this property in question, but at the end of the day, you're not going to know what actual human being is tied to that. The only way that someone can get that, I think I said this, but is a actual warrant. It's a search warrant, a criminal search warrant. It has to be served on the Secretary of State, and then the Secretary of State will disclose who that actual member is. But something short of that, no one can go just find out who the member is. So you're anonymous, right? Which we talked about is one of the most important things in an asset protection plan for real estate investments. There are some other states that also provide anonymous membership, but their fees are generally higher, or their protections are not as good, which leads me into the second reason why I like Wyoming. And that is what you see at the bottom there, charging order protection. So what is charging order protection? Charging order is a legal remedy that essentially says if you have a judgment creditor, they get a judgment against you, the remedy that they might have would be a charging order, which says that they are entitled, they can't make you sell the property, and they can't, make you do certain things, but they're entitled to any distributions of profit that you would receive from that property. What they don't receive is the management decisions, right? So if I own a Wyoming LLC and I get sued and someone gets a charging order against me, that's their legal remedy, then they have the right to receive all the distributions that I make. But I, as the manager or whatever the management entity, has control over whether or not to make distributions. So that's fine. You have a judgment against me, but you're never going to get paid because I'm never going to make distributions. Going back now to from that litigator's point of view, right? The litigator is wondering how they're going to get paid too. And if I see it's a Wyoming LLC, number one, it's going to be hard to find out who even owns it. Number two, Wyoming, the exclusive remedy that a judgment creditor can get against a Wyoming LLC is that charging order. In other states, the remedy might be that they could actually foreclose, right? They can make you sell the LLC or the membership interest or the assets in the LLC. Excuse me. Wyoming, the exclusive remedy is charging order protection. There are a number of other states that have the exclusive remedy of charging order protection. However, most of those states do not extend charging order protection to single member LLCs, which is often what we're talking about when we're talking about a holding company, right? You're going to be the single member of that LLC, holding your interest in the syndication LLC. A lot of those other states, even if they allow charging order protection, they'll actually, if it's a single member LLC, they'll give them some other rights. It's actually written in Wyoming statute that the exclusive remedy of a charging order applies to single member LLCs as well as multi-member LLCs. So kind of in sum, the reason that I like Wyoming LLCs for the holding companies is that no one's going to know you own it, right? Unless somebody discloses it somehow or another. If I tell somebody, or whatever the case is, you have the anonymity. And then number two, you have the charging order protection, which again means number one, if I do get sued, they're not going to get any money. But number two, I know that litigator's going to see that. And they're going to say, oh, it's not even worth going after this entity because it's going to be a lot of work for nothing. So that's my preferred method. Now, I will say when you're looking at a kind of an estate plan, you can also have a trust, another layer, right? We talked about these different layers of protection, a trust put in place that actually holds that Wyoming LLC or multiple Wyoming LLCs, right? That is something that you should probably talk to your estate planner when you're putting this type of thing together, but that's not a bad idea as well. And again, remember that what we're talking about is layering, right? We're just layering legal entities, separating duties in order to create those layers of defense, that defense in depth that we talked about. So about to wrap up here. I would encourage everyone to, seek counsel before you invest. We talked about a lot of things today: insurance, different type of legal entities, litigation, remedies, right? All that type of stuff, structuring, real estate syndications. It can be confusing, and it is a more sophisticated area of law. That's why we have securities laws put in place, right? Because it is more sophisticated, it is more complex. The federal laws do not let just anyone invest in securities, right? In private securities, which is what we're talking about, not publicly traded companies, but these private securities, right? You've either got to be a sophisticated investor at the very least, or you have to be an accredited investor. It's a whole world unto itself, right? A securities law. So before you invest, I would tell you to consider talking to a CPA to understand all the tax liabilities that could come from a given structure, a given investment. Talk to an attorney that understands real estate syndications, real estate laws, really has a good grasp of securities. There are a lot of attorneys out there that understand real estate transactions, but may not fully understand all the ins and outs of the security side. So finding someone that has experience in real estate securities, I would definitely talk to that person. Sponsor referrals, ask your sponsor for referrals. If you don't know the sponsor, when I say the sponsor, I mean the person actually raising the money, the person that's coming to you saying, hey, I have this investment opportunity. Ask for referrals. Do they have prior investors or other business associates, people that you can talk to try to get a gauge on that person? Because at the end of the day, they're going to be the ones making the decisions about how your money is used, right? There generally is, yes, okay, we're going to buy this real estate, but there's a lot more to being profitable real estate investors after that, right? So anyways, I would seek counsel before you invest. It amazes me how long. So I've been, putting together real estate funds, putting together real estate syndications. And it amazes me that how infrequently I receive questions from investors or their attorneys. Very rarely do I receive questions from investors themselves, but I do receive questions sometimes. They don't understand the documents, or they want to ask a question that's maybe not covered in the documents. I get that from time to time, but very rarely do I have actual other attorneys reaching out to me asking questions. And I think that's just because most passive investors don't have their own counsel to help them look at documents. And I would just, I would encourage anyone that is going to be spending a lot of money. Most of these deals we're looking $50,000, $100,000 before you spend that type of money. I would recommend, get counsel, get qualified counsel that can look at those documents, can help you put together an asset protection plan that's going to help you, that's going to work for your circumstances and your goals, and make sure that you're protected to the utmost.
Awesome.
Yeah.
Oh, perfect. I was just going to ask, Bo, first of all, thank you. Thank you for taking the time and sharing this incredible information. It's so important. And it's one of those things that I think is so often overlooked when people are passively investing. So having that extra layer of protection it's a smart move, and you could do it fairly inexpensive by setting up these LLCs. So my next question was going to be, Bo, if people had questions or needed help setting up some of these structures, how could they get a hold of you? And it looks like you got it right there on the screen.
There it is. Yep. That's it. I don't do a lot of advertising or anything, but if anyone has any questions, I love talking about real estate. Like I said before, real estate's my passion. So if anyone has any questions about a deal they're looking at, legal questions about real estate, it doesn't even have to be syndications, right? Just investing, whatever the case is, then reach out to me. Be glad to talk.
Excellent. Well, thank you so much for your time. We'll include this contact information in our follow-up email as well. That goes out on Tuesday to our entire network. So we'll include that. Bo, thank you so much for your time. Folks, thanks for joining us again for another Rev Real Estate Live. And join us next week for another one of my favorite aspects of multifamily investing. And keep an eye out for that email to learn what it's about. Thanks a lot, Bo. Appreciate you.
Thanks, Don. Thanks for having me.
Yep.